Justice Grewal, how do we make the trials more speedier?
Well, it's like this, that a typical case, a typical criminal case, not these high profile, with a lot of witnesses, a lot of documents to be proved. Typical case would take about half a day of court's time, 2 to 3 hours.
Right.
At best, the entire day. So what the court needs is 1 full day devoted to this one case. But what do the courts do? They have 20 cases and they devote 5 minutes each. So all those 20 cases then get adjourned and they go on for 3 years.
Right.
So it is like traveling, it's like a traffic jam. So you've got 20 lanes and then one car escapes and then the other one also moves ahead and all 20 are moving at the same time. Why can we not have a system where you put a barrier and you let one car proceed? Okay, now it's your turn, go.
Yeah.
And if you're traveling from, say, Chandigarh to Delhi, okay, now the road is free for you, you proceed to Delhi.
Right.
And then the next car, and then the next car. So this system has to be evolved. It has to be better case management. It used to be the case, let me tell you, in the 60s and 70s, when I was a young lawyer, this used to be the case. The trial would start on Monday morning. By Tuesday evening, the trial would be over.
Okay.
Full stop. And no adjournments and no bail. So either the man is acquitted or he's convicted. So the trial court would then on Wednesday would do some civil work. On Thursday start the next case. Thursday, Friday and finished.
Right.
You see, that system has to be. But I would like to mention something you asked about media trial. You see, courts are open. Now, if there's a high-profile case, everyone in the country wants to know what's happening in the court.
Absolutely.
And that is what media should report, what happens in the court, but should not make any observation regarding the merits of the case, because the judges are not making any observation.
Right.
So, if they just report, case was taken up at 10 o'clock, so-and-so lawyers appeared, these are the charges against the accused, and these are the witnesses produced, case was adjourned. That
so
is
observations
sufficient.
which are coming from media should not come.
Yes, they should not be judgmental. It is as if you are putting the reader in the courtroom. What will the reader in the courtroom see or observe? He will not see the final judgment.
Right. We have to go into the break. Mr. Goel, a quick comment from you on the media-driven cases.
Well, I am one with Justice Karju, who has remarked that media need to be more disciplined, self-disciplined, I would say.
Okay.
And I fully agree with Justice Grewal that media should report, not give judgment, not comment. Media's comment should be restrained, and media is welcome to make a fair reporting of what has happened in the trial.
Right. On this point, it's time to take a short break here. Do stay with us. Welcome back. We are discussing whether bail is a right of an accused or not. Justice Kariwal, do the judges apply the same yardstick to economic offences as to criminal and other offences while determining the issue of bail to the accused?
You see, a judge, when he sees the case for bail, what he would like to know is not, well, gravity of the case is one factor. Other is the accused, if he is released on bail, will he escape? Or will he harm the witnesses? Or will he, tamper with the evidence? So, if we have mechanism to stop him from escaping, as you know, in the West, they put a little chip in the ankle, so he can't run away.
Or house arrest.
House arrest. Yeah.
Or and for witnesses, and the witnesses are protected, they can be put in a safe house, or the identity can be, changed for that.
That is not done. I mean, in our country, it's not.
Unfortunate, you see, we have not reformed, and we are still running a very colonial, archaic kind of a system. If we do these things, then you give the guy bail. Okay, go.
And that's one reason witnesses do not come forward.
Exactly. So they do come forward, but if they have to keep coming to court again and again and again, and the cases are not taken up or cases get adjourned, then they get sick and tired. And next time, then they say, this is the last time I'm coming. and if my case is not taken up, I am going to just, escape.
Right.
Or say that I saw nothing. What can you do? You can't extract truth from his mouth. If he says, I saw nothing, this man has done nothing wrong. What can you do?
Absolutely. How much does the status of the accused count while considering the bail decision? Is education, his position in the society, work profile, financial resources, etc., etc.?
Should not matter, really. Should not matter.
It's the offense which
It does?
matters.
It is.
It's the offense which matters.
Yeah,
It is
but-
intense for that offense.
Yeah, that's what we are saying theoretically, but practically.
No,
okay.
practically, whether, see, if the offense is attacking a sentence of 7 years, then whether it's a rickshawala or it's a minister, he should be granted bail. The only consideration is how can his presence be secured in the court. Actually, the problem also lies with the legislature in the sense, now long back when the Supreme Court said bail is the rule, refusal an exception, the law should have been accordingly amended and this should have been incorporated in the statute itself, so that the court will have no discretion and there will be no confusion with the trial judge. We have Bail Reform Act in USA of 1984. We have a Speedy Trial Act of 1974. It says that trial will begin not before 30 days, but not later than 70 days. So 30 days are given to the accused so that he can prepare his defense.
Yeah.
And then his consent is what, when do you want? After 30 days and before 70 days, any day you want. And when the trial begins, as Grewal says, it should be continuous. It ends 1 day, 2 days, 3 days. Trial begins and it ends.
Yeah, date should not be like this
And
is
when
in
witnesses
September
come-
and then the
Yes.
other one is in November, then the in January.
And
or
then we have
February.
witnesses like doctors.
Right.
We have witnesses professionals or eyewitnesses. They are always fearful. Once a witness comes to the court, he should not be allowed to go unless his evidence is recorded.
Okay. Okay.
Yes.
Many times it happens that they are there, but the evidence is not recorded. They have to go back.
Yes,
Okay.
20 times.
And
When a
come
witness-
again.
Yes. When a witness has come, the court should make sure that whosoever witness have come to the court, their evidence is recorded before the rising of the court.
Okay. Mr. Lakhanpal, what's been your experience as far as the status of the accused is concerned? Can you recall a case where the status influenced decision of the judges?
Well, there are many cases, and you would not like to
Yeah. Fair
cite
enough.
the cases
Yeah.
as such.
But you agree that
It does affect, and there are many such cases, in fact, where the assault goes on.
Okay. Mr. Goyal, in your experience on bail matters, has status been a greater impediment than apprehensions, like the accused possibly influencing the witnesses and tampering with the evidence?
No, it's
Just-
other way around. It works against him. More the status, more it works against him because for two reasons. One, it's more, it attracts the media.
Okay.
Two,
Coming back to the media
yes.
again, okay.
No, it attracts the media. And it's, suppose, should I name or not, there are cases where suppose a High Court judge is involved, a senior bureaucrat is involved, there are cases where an IAS officer is involved, a chief secretary is involved. The trial judge is very cautious that High Court should not think that I have been influenced by his status. So even if it's a case of bail, he will not grant him bail.
Okay.
And the media will keep repeating the charge. The judge is mighty influenced by the media as well as by the status, and he will refuse him bail and send him to bail.
Absolutely. Justice Grewal, how subjective are these decisions? Can they vary from judge to judge?
Normally they don't, because each judge has his own standard of granting bail. Some judges are very strict,
Right.
but they're uniformly strict. Some judges are liberal, but they're uniformly liberal. You see, if you're strict in one case and liberal in another case, then it reflects on your. But there's one point I would like to mention, is that our law requires that within 24 hours of arrest you have to be produced before a magistrate. So there's a limit of 24 hours. If investigations are not completed within 60 or 90 days, bail has to be granted. And if a person is arrested, detained without trial, and his case is not approved by the advisory board, then after 3 months he has to be released. So we have time limits, and trial has to be conducted day to day. That is also provided in the law. Section 309 CRPC
Okay.
provides that trial has to be conducted day to day, shall not be adjourned. So if we are not able to conduct the trial day to day, then give him bail, for God's sake. I mean, why detain him? It's very unfortunate. It's a great travesty of justice.
She said the rule book is not being followed.
It is not being followed. The trial courts are not conducting trials on day-to-day basis.
Okay. Mr. Goel, what degree of subjectivity do you encounter? Is it 50% of the bail cases, more or less?
I would say it's more than 50%. Because the moment there is a high-profile case, because we are discussing with the high-profile cases in my mind.
Absolutely.
In every high-profile case, I would say the judges are subjective. They are either influenced by the media, or they are afraid of their superior judiciary, and their subjectivism is a lot influenced by the status of the person. That I should keep him behind the bar so that my ACR is not spoiled.
Okay, you will agree with that, Mr.
I would. It's getting more, in fact.
Okay.
It's getting worse now.
The 50% is a very
if the
little.
Supreme Court says something, how can the poor magistrate, give him a fair trial?
But denial of bail, the Supreme Court in 2G case,
Yes.
not, ADJ can't dare to grant him bail, even if he wants to grant bail.
Okay. Oh, that's interesting. So, yeah.
Too much interference by the High Courts and the Supreme Court. These are trials, these are criminal cases which have to be tried, and the trial judge is supreme. There will be an appeal. Okay, things can be sorted out in appeal. But
Right.
before the trial is over, the judges are pronouncing on these cases, and that one miscarriage of justice took place in the case of Bhopal gas tragedy, where they said this is not a case of manslaughter. So the people were convicted for only 2 years, sentenced for 2 years for a rash and negligent act. They should have left that decision to the trial court.
Mr. Lakhanpal, what do you do for the accused if you are convinced that the bail should be allowed and it is not allowed? Appeal the decision and go to a high court?
Yes, we can go to the High Court, we can go to the Supreme Court, but then once the bail is denied by the lower court, then the High Court doesn't interfere all the time, and Supreme Court interferes very seldomly.
But do you find a redressal there always?
Not always, but
Okay.
if we have a good judge like Justice Kariwal, yes,
Okay.
but not all the time.
Okay. Justice Kariwal, how do the judges prevent a situation where the accused is wronged and it becomes miscarriage of justice for a variety of reasons?
Well, at the moment there is no law to compensate them.
Okay.
But certainly this requires to be looked into. You have victim compensation, you should also have innocent accused compensation. You should be paid.
Right. Mr. Lakhanpal, what happens when it turns out that the accused has spent time in custody and has finally been discharged from the case by the court?
Nothing. He has sit home, sit pretty. Thank God he's out.
Okay. That's
And for
the
all
least he
that
can
he
do.
has wasted, his life is gone. In India, we have no redressal.
There's no
You may have spent 10 years, you may have spent 14 years, 15 years in jail, found finally innocent. Nobody is going to compensate you for your 15 years, not even a penny.
Mr.
Yes,
Goel, how
that-
does it work abroad, I mean in US?
Well,
let's say?
actually in US it never happened that you are in for 10 years and then you are acquitted after 10 years. As I said,
Right.
the trial begins 30 days to 70 days. The minimum 30 days accused is given to prepare his defense and maximum 70 days.
Right.
Then that the trial will begin, the case will be finished within a month or two.
A final word from you, Justice Kariwal. How can this be prevented?
Have more judges.
Okay.
Each judge should be given, say, 5 or 6 trials only. And when he finishes, they start moving ahead, and then he gets more trials. There should be a sort of a judge who holds the trials back. They don't go into court. You have to do it once. It may take a year or two, and once you streamline the traffic, then things will move smoothly.
Right. Thank you so much for coming into our studios this evening. In most cases, bail is a matter of right, indeed in letter and spirit of the law in our country as in the rest of the world. However, its application in the interest of the rights of the accused till he is proven guilty has yet to evolve. Unless that process is hastened by all the stakeholders, it will continue to be subjective and uneven, and the affected parties will continue to escalate the matter in superior courts to find relief. With that, we end this edition of Prime. Till we meet again, good luck and goodbye.